All right, good morning, everyone, and welcome to this update. We want to discuss something that's actually pretty boring, to be frank, but still something that is creating a hell of a lot of confusion in practice. I just 2 weeks ago had to serve SARS the legal notice because they cocked up the process. And so it is something that I often also hear people get contradictory views from SARS as to when do you follow remittance, when do you follow objection on penalties. It's just, it seems in practice it's not clear, when in my mind the law is pretty clear on it. So I want to discuss that, and then I wanted to touch base on something that it kind of goes hand in hand with this issue of, when SARS does things, what powers do you have as a taxpayer to act against what it is they've done? And to understand that you have powers and to understand what it is you must do requires of you to understand what it is SARS has done, and we'll talk about that, because everything SARS does can be classified into one or two things. And once you get that, you will see that it becomes clearer. All right. As per usual, this training is intended for my staff, for those of you joining online, for your interest's sake only. Before we get into the session, I thought an honourable mention is the Poulter judgment from the SCA was handed down last week. I think it was, where the SCA confirmed that anybody has right of appearance in the tax court, because the tax court is not a court of law. Right. This I found, I can probably talk for the whole 30 minutes about the judgment, but I found it fascinating that SARS appealed the full bench judgment of the High Court, where the High Court, full bench of the Western Cape High Court, said yes, anybody can appear in the tax court. And then they decided to insist that it must be a legal practitioner, and so they went all the way to the SCA. In the meantime, though, they changed the law, I think it's section 125 of the TAA, to say anybody can appear on behalf of the taxpayer, provided the president of the tax court declares the person fit and proper, but the date of commencement of that provision is a date to be gazetted later, which hasn't been gazetted. So obviously they made the amendment and waited for the judgment in the Poulter case to come down, so we'll see where that one ends. So the point is, anybody has right of appearance in the tax court. That doesn't mean you should go and appear in the tax court, but it means you can. And I always say, be careful of people who try to sell you that they are good because they've got right of appearance in the tax court. It's like saying you've got the right to breathe. It's not an achievement. Everybody's got the right to appear in the tax court. All right. Right. I see there's people in the lobby. All right, let's talk about these Chapter 15 penalties, right? So, because that's where the issue comes in. When we talk about penalties, we have to say, well, we've got Chapter 15 penalties, and then we've got Chapter 16 penalties, right? Chapter 15 penalties is the fixed amount penalties, the 210, failure to file a trust tax return, now recently from the 4th of April or whatever, 4th of May. Failure to file an income tax return for an individual, failure to file a corporate tax return. That's the Section 210 penalties, right? That falls into Chapter 15. Section 212 penalties, failure to report a reportable arrangement. That's a penalty under Chapter 15. 213, percentage-based penalty for late payment of taxes, right? Any percentage-based penalty. Underestimation of provisional tax. We'll go through the examples. Right, so these penalties, 210, 212, 213, these penalties as being very distinct from Chapter 16 penalties, which is understatement penalties, right? The old additional tax penalties. Well, I speak to you guys as if you know the old additional taxes, but I think most of you are too young, right? But talk about the old additional tax or the understatement penalties, that's Chapter 15. So the path for the imposition, if SARS imposed these penalties, fixed amount, the 250 a month, 212 reportable arrangement, 213 late payment of VAT, PAYE, provisional tax underestimation, blah. These are imposed by 214, but the route to challenge these is not to file an objection, right? So just a few examples. I think most of you are familiar with this. You know the percentage-based penalties. I think the one that I want to highlight here is provisional tax underestimation is also a percentage-based penalty in terms of Chapter 15, because when you go and read the fourth schedule, paragraph 20, it says that this penalty is deemed to be a percentage-based penalty imposed in terms of Chapter 15 of the Tax Administration Act, right? And again, that's important to understand because it guides you as to what is the correct process if you take issue with this penalty. If it's a Chapter 15 penalty, your first instinct is not to object. The first route is to request remittance of the penalty, RFR, right? So identify this penalty that you're looking at. What sort of penalty is this? Is this a penalty in terms of Chapter 15? In other words, is it a fixed amount penalty? Is it a percentage-based penalty? Which is, let's be honest, for the most part, I think that's pretty much it. I don't see a lot of reportable arrangement penalties, right? So that's about it. And then section 215 says you must request remittance, and then we've got grounds for remittance, right? But you can't object. You must first ask for remission, and if SARS refuses remission, then you can object to that decision, right? You can't go and object directly. Right. This is crucial because, and a lot of people have said to me, why, Nico? Because a penalty assessment is still an assessment. Not quite, because assessments are dealt with, it is a determination of a tax liability, because I think the word tax is defined in TA to include a penalty. So one could perhaps say it falls into the definition of assessment, but it's not the same as normal assessments, which falls into, I think it's chapter 9 or 8, right? This is chapter 15. It's imposed by way of a penalty assessment. And here's the crucial part is, if you think this through to conclusion, the chapter 9 dispute process, when you have a dispute about penalties, let's say you want to take this ridiculous stubborn approach that some people have, say you can object to it because it's an assessment. So, okay, fine. Let's then go all the way through. Your objection gets disallowed. You go to ADR. ADR is disallowed. You go to court. Now you end up in section 1 to 9. The court has to make a decision, right? And in the court, the taxpayer bears the burden of proving that an assessment is wrong, right? So if you placed the penalty assessment as opposed to the decision under objection, then your burden of proof in the tax court is to prove the assessment wrong. And if you paid the VAT late, you paid the VAT late. You're going to lose in tax court. And it's going to be 2 years later, you're going to waste the client's time because you can't prove that the penalty assessment is wrong. It's right because you did pay it late or you did underestimate the provisional tax. There's a massive difference if you object to the decision, because now if you get to court because SARS, you request remittance, SARS says no, right? Then you object. Now you get to court. Now your burden is proving SARS's decision wrong. Now you can say, yes, I paid it late, but there are mitigating circumstances as contemplated in 217. There is reasonable grounds. The non-compliance has been remedied. It is a first incidence of non-compliance. Now you actually have a chance of getting it through. But if you place the assessment under dispute, you're going to lose ultimately in tax court, right? So you must first do the objection after request for remittance. And when you request remittance, you must give SARS or tell them what led to this imposition of the penalty, and then of course you're going to rely on sections 212 and 213 to request remittance. So I'm not going to cover what those sections say. I think most of you are familiar with them. Here's a quick layout of what they are. But for the most part, we're dealing with, and look, to be honest with you guys, I don't like to touch fixed amount penalties for non-submission of returns, because when you look at the circumstances under which SARS can remit those, it's up to 2,000 Rand. Right, even if you prove all the circumstances, unless you can show there's exceptional circumstances for the delay, in which case section 218 applies, right? And that's kind of the toss-up that you need to always consider when you look at a penalty assessment. You're going to request remittance. You need to understand what are the facts and circumstances that led to this, because SARS only has a limited discretion, and that discretion for them to remit is contained in section 217 in the context of chapter 15 penalties, is contained in section 217. And effectively 218. 219 talks about when the penalty is incorrectly imposed. I can talk about that for half an hour on its own, but I'm not going to do that today. So often you'll find that SARS, for example, will come back on a request for remittance and say, no, the non-compliance has not been remedied, right? Which clearly what they're trying to refer to is 217, which is one of the remittance grounds as the non-compliance must have been remedied. But what you've explained is exceptional circumstances, right? So whilst indeed it might not qualify for remission under 217, it qualifies for remission under 218 if your case is exceptional. And they've got this new thing where they declare requests for remittance as invalid, which is absolute nonsense. There's no provision in law that allows them to do that. We'll talk about when SARS does things that's wrong. Right, so example of a VAT case, VAT was paid late and SARS raised the penalty. So you're going to go and file a request for remittance. You're going to say, well, look, it's a percentage-based penalty, so for me to get remittance under 217, I'm going to show that it's a first incidence of non-compliance, which means there's no other penalty in the last 3 years, right? The non-compliance has been remedied. I've now paid the capital tax, and there's reasonable grounds for the non-compliance, right? That is difficult. First incidence is always the one most people trip up on, right? Because they find that, oh, this is VAT, late payment of VAT, but 2 years ago we had a late payment of PAYE, so yeah. And it's and requirements. 217 are all and requirements, right? So if you trip up on one, you fall out of 217, right? There's technical ways and means we can argue around 217. I do that often, where I say, well, yes, there might be a penalty on the PAYE 2 years ago, but there's no penalty assessment for it. right? And what the definition of first incidence refers to is one for which a penalty assessment has been issued. So you go and show me where's the 214 penalty assessment. It's not there because it didn't exist at the time, because your systems didn't cater for penalty assessments. So this is a first incident. So let's not split hairs about it, right? So there's ways and means around that, but not always. And then you have to go to 218. And 218 is difficult to prove, right? Because it's exceptional circumstances. And here's the kicker. It's the same with asking for condonation, because they also use exceptional circumstances, and 218 is often quoted in the context of getting condonation when you are exceptionally late and you need exceptional circumstances. The exceptional circumstance must be the cause of you not paying the VAT on time, right? Not there was exceptional circumstances at the time. I had a case where people briefed me. They said, "Oh, the FD of the company died." I said, "Okay, did the FD file the VAT returns?" "No, the financial manager did." "Okay, fine. Was everything processed beforehand? Was it ready to file?" "Yes, the financial manager just didn't file it because he didn't." Right. So the death of the financial director, although very serious, I'm not trying to suggest it's not serious. It's not the cause of the non-compliance, right? So you must always make sure that when you go into 218 as a ground for remittance, you need to show that the cause of the non-compliance is the exceptional circumstance. There was a outbreak of some rat virus on the ship, right? And therefore I could not file the return because I was sick, and it happened to be on the 31st of the month or the 25th or the 7th or whenever the return is due. That is a direct link. I'm just using that as an example, right? It's not the rat virus, it's called something else. Provisional tax underestimation. This is very commonly misunderstood because it always forms part of an assessment to tax. So in a single ITA 34, if you talk about income tax, you'll have the assessment to tax, and then you'll also have the underestimation of provisional tax. So that assessment is two things. It's an assessment in terms of either 91 or 92, which is Chapter 8, and then it's got a component, which is a Chapter 15 penalty assessment that should be compliant to Section 214. Right? And so it's two things. And so you should be requesting remittance for that penalty. Now, I know that the people will say, but if I take issue with the objection, if I object on the merits and I succeed and the taxable income comes down again, then there wouldn't be an underestimation of provisional tax. That's true. But the way we approach it in practice is we'll say, well, fine, if we don't succeed on the merits, then we need to get remittance. And so what you must be careful of doing is, it is very easy to fall into a trap here, because if you object, you're objecting to say the assessment was wrong. If that wrongness that you're objecting to was also the cause of the underestimation penalty, then filing a request for remittance looks like you're saying, I accept the assessment is wrong, but I say there's extenuating circumstances. So when you want to file at the same time, which we often do, is I'll always file my request for remittance and I'll say, I'm filing this without prejudice to my grounds for objection, in alternative to my objection, right? So if my objection were to fail, which I don't think it should, but if it were to fail, without prejudice to that process, I'm filing a request for remittance now, right? Because there's a big issue about requests for remittances, and because they also tend to invalidate it. I just had to serve 11-4 notice on them recently to say, you invalidated. We did one. Who did one recently, right? A request for remittance that SARS invalidated. No, it was you guys who did one. There was a request for remittance that was invalidated, and they can't do that. They wanted to say they disallow it. They don't want to allow the request, right? But by invalidating it, and then they confuse it with the provisions of Rule 7.5. So they can, you've got 20 days to file a new. There's no such rule in the Tax Administration. I don't know who taught them these things or where they come to it. I mean, it's nonsense. Right, so anyway, so now we have to go and we serve them with an 11-4 notice and say to them, you're acting illegally, and then they fix it. It's unfortunate that that's what we have to do, but it is what it is. For those of you who are joining late, please, as per usual, these sessions are recorded. They are available on the Unicus Tax YouTube channel. All right, let's move on then, because this kind of fits hand in hand with this notice of invalidity. And I want to do this briefly because, again, I can talk 8 hours or 6 hours just on this topic. But SARS often does things where, and I alluded to this earlier, SARS often does things where taxpayers feel powerless, or they don't know what to do. They can't figure out exactly what, they feel SARS has done something wrong, but they can't figure out what is the correct way of challenging it. And there's pretty much always something that you can do if SARS did something that you're not in agreement with. Right? Not always, but pretty much always. But before you can figure out what it is that that you can do, you must understand that everything SARS does, insofar as it relates to taxpayers, in terms of their relationship with taxpayers, everything SARS does will manifest in either one or two things, either an assessment or a decision. That's it. There can be nothing else, right? Either they made an assessment or they made a decision. So an assessment is normally, we all know what assessments are. It's a number, an ITA 34, VAT 217, EMP 217, etc., right? Or it's a decision, which is normally not something that manifests in a number or tax liability, a refusal to grant suspension of payment, a decision to take collection action. Inaction is also a decision. Refusal to reflect the taxpayer as non-compliant. That's a decision not to reflect it as compliant, or a decision to reflect it as non-compliant. So everything SARS does, when they take money out of the taxpayer's bank account, there was a decision to do that, a decision to write the taxpayer a letter threatening them to take collection action. Those are decisions that they take. But not everything SARS does is subject to objection and appeal. And what is important is you need to understand what falls into what process, so that you know what legal challenge you must launch if you take issue with them, right? So we all know what assessments are, right? So EMP 217s, VAT 217s, decisions, refusal to remit, a penalty, we discussed that, refusal to condone a late objection, refusal to grant suspension of payment, which they like to do nowadays, etc., right? So we all know what these things are. Now, your gatekeeper, really, you have to figure out, is this assessment or decision something that I must challenge to the tax court process, or can I go to the High Court directly, right? So Section 105, although technically I can drill it down one layer down further, Section 104 is your gatekeeper, is your decision tree. That's the thing that makes you decide what you're going to do, right? Because 104 says you can object to assessments and certain decisions, not all decisions, certain decisions, right? So, and then I'm not going to go through the examples, but there are examples of assessments you cannot object to either, like a 19.3 increase. You can't object to a 19.3 increase, right? It's technically an assessment, but you can't object to it, right? But you have to go and say, okay, I'm unhappy with what SARS has done. What is it? Is it an assessment or a decision? Okay, it's an assessment, fine. Is this an assessment that falls into 104? Yes, okay. Then if you take issue with it, you must go through the objection process. Now, that's what it must be. It's my horse, what it is, unless you can get the High Court to direct, otherwise, good luck after UMK to get that, right? So, if they've made a decision, and it's not a decision contemplated in the very narrow ambit of Section 104.2, then you can't go through the High Court process. Then you have recourse to the, you can't go through the tax court, then you have recourse to the High Court. Right. Ultimately, and here's a little bit of a decision tree for you to go through on your own time, but if you've got access to the High Court, to the tax court, you'll go through we all know, the objection and appeal process and all its strings and bells and whistles attached to it. If you have to go to the High Court because it's a decision that's not subject to objection and appeal, that process is preceded always, unless in very exceptional circumstances, by the service of an 11-4 notice, right? And all these decisions that SARS take, decisions to take money out of a taxpayer's bank account, a decision to reflect the taxpayer as non-compliant, a decision to whatever, right, is not subject to objection and appeal. A decision to invalidate a request for remittance, it's not subject to objection and appeal. Does that now mean SARS can do what they want? No, it means you've got recourse to the High Court. But before you go to the High Court, you must serve this 11-4 notice on SARS, right? Because 11-4 says if you intend to institute any action against SARS on the High Court, you must give them 10 days notice. And in 99.99% of the notices that we've served, and we do these weekly, right? Almost. It's quite ridiculous that we have to do them weekly, but I've never ended up in court. I had SARS fix the issue, pay back the money within days, right? SARS pays back the money in days, they reflect the taxpayers compliant within days, not 7 days later when the Ombud has decided to look at it and escalate it to the Tooth Fairy and Father Christmas, and then they sit for 5 weeks and make a decision on it, right? So this is a very effective remedy, but then those 11-4 notices need to be properly drafted, and you need to make sure you have a case, right? There is a Rule 56 process that's available to keep SARS in check. And I mention this because it's a very powerful tool. I think many people are familiar with it, but I'll mention it anyway for those who are not familiar with it. So Rule 56 fits into Chapter 9 disputes, right? So when you think about that umbrella, we've got 104 that deals with objections and appeals, and we've got 11.4 that deals with High Court action. So Rule 56 fits into the umbrella of Chapter 9 disputes, right? But it deals with something, it's if you dispute something about the dispute process, where you hold SARS in breach of a rule. So SARS doesn't answer an objection within time, which is very common, right? Or they refuse to give reasons, or whatever the case might be, where there's some obligation on SARS. It cuts both ways, but in the context of this discussion, we're talking about taxpayers, then you can serve a notice on SARS in terms of Rule 56 of an intention to institute default judgment action against them in the High Court, which I'll tell you now is the same kind of concept as an 11.4, but in relation to an interlocutory process in the tax court. It is one of the most effective ways to get SARS to cure their default. Because what's the alternative? SARS doesn't answer the objection in time. The alternative is escalate. I don't know where those escalations go, and if the escalations even have a ceiling. Because you call escalate, you call again, no, we've escalated it further. I don't know where the ceiling is of escalations. Maybe at the commissioner's desk, I doubt it. But, or a complaint, of course, is the alternative to the CMO, I think it's called, or the ombud. Those things are also good and well, right? But Rule 56 is just much more effective. SARS, you're in default of the rules. You've got 15 days to cure it. If you don't, I'm just going to squash this assessment in consequence of your default. And they tend to take these quite seriously. I've got one application of all the Rule 56s I filed. There was one that ended up in court. We were unopposed. We won hands down, 200 million rand assessment squashed, right? 220 million rand assessment squashed. And we've got another one that is pending that I won't say anything about because it's pending. Right, I don't think we'll probably put it on the roll the end of this week. No, it's already on the roll. It's already on the roll. It's going to be happening soon. Right, Section 11.4, High Court pressure. The service of this notice doesn't mean you have to institute action, right? But if you do this properly, if you serve an 11.4 properly, it is exceptionally powerful, right? But it does require you to put in a little bit of effort. It does require you sometimes to do a little bit of SARS's work to set out timelines and things, because people often complain, but SARS has all this information that you're attaching. So I know they have all the information. But do you know how big an organization SARS is? Do you know how many thousands of employees work there? Right? That legal official that gets the 11.4 notice has got no idea. He or she has to now go and find out. They've got 10 days to figure out the issue that you've been trying to solve for 3 years. Right? So what we like to do is we like to set out a whole sequence and a chronological list of events with all the documents attached. Why? Because it makes me get resolution within a day or two, as opposed to SARS coming back, can I please get an extension to the 10 days, blah, 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 blah. Right? Examples of 11.4 notices, we've served many, right? Tax compliance status reflects as non-compliant when there's a suspension of payment in place and they shouldn't be reflecting as non-compliant. You challenge the status on e-filing, SARS says, yeah, right, nothing happens. You complain, nothing happens. You complain to the ombud says to SARS you must reflect it as compliant, nothing happens, right? Not that you have to go through all those steps first, but what we do is listen to the client, SARS is wrong, 11.4 notice, 2 days later, compliance issue sorted out, right? Same with money taken. We got that 4.6 million rand, which is one we did recently, where SARS took 4.6 million rand of the taxpayer's bank account illegally, right? And that's typically what happens. The client calls you and says, hey, what's happening? You're not doing a job, or SARS just took the money. Says, no, they're doing it illegally. And then some clients are obviously naturally a little bit, they don't trust you because SARS is SARS, and SARS don't do things illegally. You'd be surprised. My friends, they do many things that are illegal, and I've got the evidence to show it. Not everything. Please don't quote me wrong. I'm not saying everything SARS does wrong, but they often do. And so we had the 4.6. They took the money. We served the 11.4. Was it 2 days? Whose case was that? Please just raise your hand. Was it the two of you? And how many days did it take for SARS to repay the money back to the client's account after we served the 11.4? Was it a day or two? Maybe a week. Can't remember. Right? But it's still much faster than submitting something that's going to take 15 days to look at, and then 15 days to escalate, and then 15 days to have someone look at it, right? It's very, very effective, right? So the point is, and there's lots of examples of SARS taking money out of the taxpayer's bank account. The point is if you look at, first of all, we must first this is a dual session, right? One is Chapter 15 penalties. The process is request for remittance, decision not to remit, object and appeal. If SARS declares it invalid, that's not something that they can do. The TA doesn't give them that power, right? So that's also not something you can object to, which brings into play Section 11.4, right? The High Court's jurisdiction, and we've done it many times before. We say to them, listen, you're invalidating this thing, and I'm not trying to suggest you must allow my request, I'm just simply suggest you must entertain it, but you can't invalidate it. even if you think the requirements of 217 is not satisfied, because what's the point then, right, of the appeal and objection process if SARS is just going to invalidate the request for remittance for want of compliance with 217? You'd never be able to test it in the court, because they just keep it out until they allow it. So either the request for remission will either then be allowed or invalidated. So why do we have the ability to object to decisions not to allow it and all the way to the tax court? So it's clearly wrong. They're confusing the objection process. So remission first, then object. If SARS does something, and you're not happy with it, which is kind of a different point, if SARS does something and you're not happy with it, you have to go and figure out what it is they've done. Is it an assessment? That's a numbers thing, right? Or is it a decision? Then go and figure out if that assessment or decision falls subject to Section 104. If it does, you take issue with it, you go through the Chapter 9 objection and appeal process. If it's a decision or assessment that doesn't fall into 104, and there are thousands of decisions that do not fall into Section 104.2, and there's about, I can't remember exactly, but if I were to guess, about 10 or 12 types of assessments that you can't object to either. So assessments, for the most part, you can object to. But if it's one that falls into 104, object. If it's not, then you can go to the High Court, serve 11 for notice.